So welcome everyone to tonight's constitutional conversation. It is my pleasure to welcome again to Stanford Professor Philip Hamburger, who is one of the nation's most distinguished legal historians, who, and especially in the class of legal historians who also pays serious attention to current constitutional controversies, which is, I think, where we're going to hear from him tonight. He's written really some of the most important books about legal history, and Law and Judicial Duty is perhaps my favorite. It's not a light read, though, so you really need to bear in. He also wrote a very interesting book on the separation of church and state, and he and I go back, I don't know, 30 years maybe. I remember when I was chair of the appointments committee at University of Chicago Law School, one of my biggest projects was to try to get him to come to Chicago, and he later did as soon as I left, which maybe he'll start speaking as soon as I leave from the front of the room. So I think that's what I'm going to do. So please join me in welcoming Philip Hamburger.
Michael, for that very kind introduction. It's an honor to be here, particularly with this very honorable audience. Thank you all for coming. I hope not to put you to sleep, but give me a chance. So I have a strange thesis, which is that judicial doctrine invites censorship. This may seem odd. The First Amendment protects freedom of speech, and judicial doctrine still bars most overt suppression. But even in prohibiting censorship, doctrine permits evasions. It leaves open some pathways for suppression, and it thereby permits what it allegedly forbids. I've developed this argument in an article called Courting Censorship, which was kindly published by Eugene Volokh in his Journal of Free Speech Law. Today I'm going to lay out some of those arguments, and we'll see whether you like them. I think they're persuasive. We'll find out. The organization today will be as follows. First, I want to talk about what I call sub-administrative and privatized power. We'll see how it invites wholesale suppression of speech. Second, I want to talk about the state action doctrine, especially as espoused in a case called Blum versus Uretsky, and how it legitimizes censorship as long as it is privatized and not overtly coercive. And third, I'd like to talk about free speech doctrine, especially the conflation of the words abridging and prohibiting. This reinforces the mistaken emphasis on coercion. Fourth, we should talk about the censorship itself and see how it evades or minimizes constitutional obstacles. And fifth, briefly, I'd like to look at remedies to see that judicial doctrine actually makes it very difficult to secure effective remedies against the censorship. So, first, sub-administrative and privatized power. And how does this combination invite what I call wholesale suppression? Our traditional conception of the threat from government assumes retail prosecutions for seditious libel. But government increasingly is sub-administrative and privatized. It works in different ways. And these developments permit this wholesale suppression in place of retail prosecutions. What do I mean by this? The cutting edge of power these days is sub-administrative and privatized. In the 18th century, the Constitution promised us the rule of law, that is, regulation by act of Congress. In the 20th century, the administrative state substituted the rule of rules, that is, classic administrative regulation typified by notice and comment rulemaking. So we have the rule of rules instead of the rule of law. But all along, something else was going on. Agencies sometimes descended to less sanitary mechanisms. It included administrative extortion, third-party boycotts, hints of retaliation, etc. Nice business you've got there. How many site visits do you want this week? Oh, good. Let me tell you what some other things you need to do that are not in the regs. These are what I call sub-administrative mechanisms. They don't fit the classic idealized account of the administrative state in which agencies with their expertise publicly make rules. Instead, it works below that level to get a lot of other things done. And these sub-administrative mechanisms are most effective when they're also used to corral private institutions into regulating. And we've seen a number of examples of this recently. Operation Choke Point, right? The Vullo case currently in front of the Supreme Court, in which the head of the financial department in New York, Ms. Vullo, simply told the banks and insurance companies, well, dealing with NRA, that carries some reputational risk, which is code word for regulatory hassle. And of course, then they denied banking services, et cetera, to the NRA on account of its viewpoint. And then, of course, there's another example which weighs on me particularly, which is the current censorship through social media platforms. All of this is privatized regulation working through corporations. In the 20th century, the combination of sub-administrative power and privatization has become the state-of-the-art means of evading the Constitution. Together, they constitute the worst of the new administrative state. Although this is a profound development, the judges scarcely recognize it. And that's because they permit the sub-administrative and privatized power on the theory that there's no coercion and no final agency action. To be precise, they say that there's not the sort of coercion or final agency action that would make the agency action reviewable. For details, see 5 USC 704 or the case Bennett versus Speer. In other words, the judges used very tight ideas of coercion and final agency action to shut their eyes to the grotty realities of power these days. Now, why does all of this matter for censorship? The sub-administrative and privatized power allows wholesale control to displace that retail prosecution familiar from the 18th century. 18th century censorship began with a statute, such as the 1798 Sedition Act, which applies to individuals through retail prosecutions. In other words, it required the active cooperation of Congress to adopt the law, and then the courts to let the executive prosecute, and indeed had to persuade a jury. The executive could not actually suppress speech, but it could only punish the speaker, and it had to charge him with seditious libel and prove the case to a judge and jury. This was retail adjudication, and it protected speech and other rights. So that we look back to this era and look at the prosecutions and say how terrible, and it was terrible, nonetheless, it wasn't that bad precisely because the government had to get Congress to pass a law and had to have the courts sustain a prosecution in which the government had to prove a charge against an individual and a chance to defend himself. Nowadays, however, the government can sidestep Congress and the courts. It can use threats, raised eyebrows, offers of coordination, and so forth to get the platforms to suppress their users' speech. The government doesn't have to prove anything against anybody. Yet it can make vast amounts of speech just disappear, poof, and it's gone. This is wholesale suppression of opinion achieved through sub-administrative and privatized power. And it makes the old punishment of individuals through seditious libel prosecutions look positively genteel. Now, what precisely is so dangerous about this new wholesale suppression? It places the onus of going to court on the censored. The censored once merely had to defend themselves when prosecuted. Now they need to go to court to stop the censorship. And it flips around the burdens of proof and persuasion. The government once had to prove guilt before punishing an individual for his speech. Now each individual has to prove that the government censored him and that the court should grant a remedy, just in order to make his words visible. In some very tight judicial ideas about coercion and final agency action have enabled the growth of sub-administrative and privatized power, and for speech that means wholesale suppression in place of retail prosecutions. Okay, enough on that. Here, let me just. Second, let's turn to the state action doctrine, especially as espoused in Blum versus Uretsky, and see how it legitimizes censorship as long as it's privatized and just not too overtly coercive. State action doctrine has its foundations in the 14th Amendment, right? It recites no state shall. And from those words, we get the state action doctrine, in which the judges create a generic measure of what is state or government action. Whether for the state governments or the federal government, it's still called state action, and it involves a degree of state force. Indeed, The coercion yardstick becomes especially important under the state action doctrine when plaintiffs claim that private actors violate constitutional rights. Now, often that is done when the government is entirely passive and there's an attempt to use constitutional law against private actors in ways that seem to go beyond what the 14th Amendment and other constitutional rights would permit. And the Supreme Court responded with a combination of what it calls a conversion and coercion requirements. The plaintiff must show that private action has been converted into government action, usually through government coercion. And this coercive coercion conversion test makes sense in a suit against a private actor. The Constitution limits government, not private actors. So if you're going to sue a private party on the claim that it's violated the Constitution, you really need to show that the private actor has been converted into a government actor for these purposes, and that's usually, according to Blum versus Retsky, only when there is a degree of coercion. But let's flip it around. What if one is suing the government for using private entities to violate rights? You know, it's not just a case in which you're suing a private entity under the Constitution, but where the government has used private entities to suppress your rights, and you're suing the government itself. Then it doesn't make sense to ask whether the government has coercively converted the private action into government action. But in the early 80s, a case called Blum versus Uretsky applied the same state action standard in cases against the government. It said that when you sue the government for using a private cutout to violate your rights, you need to show that it coercively converted the private action into government action. That's a very high standard. So Blum signals that privatized censorship is okay. The government can suppress speech through private cutouts as long as it does not use overt coercion that would convert the private action into public action. Blum's conversion and coercion requirement clearly goes too far. Logically, it doesn't make sense because government can violate rights through private parties without converting their action into government action. It also departs from precedent. As Eugene Volokh has pointed out, when the police ask your roommate to search your apartment, they don't have a warrant to go into your apartment, they don't have any reasonable cause to do so, but nonetheless, they find your roommate and they say, hey, can you just take a look around and see if you can find any good stuff there? The government, in that instance, is not coercively converting the private search into government action. It's entirely voluntary, but the search is clearly unconstitutional, and courts have held this. So Blum is surely mistaken. Unfortunately, however, Blum's interpretation of state action seems to tell the government it can get away with censorship as long as it uses private companies and is not overtly coercive. By the way, let me turn this off again. By the way, there probably are internal government opinions on this that were written sometime about 4 years ago, but I haven't got them. One can tell, however, that the government is responding to this way from their pleadings. And in respect to other instances in connection with IRBs, I actually have gotten into government records from the 1970s, and there you do find opinions and letters where they explain how they respond. And I think they're doing the same sort of thing here, looking for doctrine that might plausibly excuse them and running with it. So, having done with state action, let's turn third to the First Amendment itself and free speech doctrine. The problem here is that the Supreme Court doctrine conflates the words abridging and prohibiting, and this again invites censorship. And by the way, this is what I find the most interesting part of all of this. It's rather astonishing to find something so interesting and so textual being entirely ignored. The First Amendment distinguishes abridging the freedom of speech from prohibiting the free exercise of religion. Prohibiting once meant a range of coercion or pressure, including mere hindering, according to Samuel Johnson. In contrast, abridging meant reducing or diminishing. It was not a lesser yardstick, but it was a different yardstick. It was a different measure of what a prohibited government action. And this was well understood in the 18th century. It was quite traditional to speak about abridging the freedom of speech or of the press. And in this context, the word abridging was traditionally understood to mean reducing, restricting, or diminishing. And there are a host of 18th century sources that show this. Moreover, in the course of drafting the First Amendment, Congress deliberately distinguished between abridging the freedom of speech and prohibiting the free exercise of religion. They were bundled together originally, and the verb used then was infringe. And then they separated them out and used different verbs, abridging and prohibiting. So they clearly were thinking about this and reverting to the customary way of speaking of freedom of speech, which is with abridging. And this is important because the First Amendment thus bars any reducing or abridging of the freedom of speech, not coercing or prohibiting that freedom. The text of the amendment thus seems to repudiate any coercion measure. Indeed, the abridging or reducing yardstick would seem to bar government from using even consensual mechanisms to suppress speech, because without any coercion, without any prohibiting, you can abridge or reduce the freedom of speech simply by making a deal with a large private company. So the abridging measure, if that's what the Constitution says, and it does, seems to cut off all the evasions that were invited by the coercion yardstick that we saw in Blum versus Uretsky, and that is, seems to be adopted by the court when it thinks about prohibiting the freedom of speech. Put simply, if you want to think of it in terms of the academic literature, we should follow the example of Nicholas Rosencrantz. Nicholas Rosencrantz wrote articles on the subjects of the Constitution and the objects of the Constitution. In other words, he took its nouns seriously. And all I want to say here is we should take the verbs seriously too. The verbs also matter. In terms of state action doctrine, maybe it's a mistake to think there's a generic state action doctrine that applies in all instances and always involves something like coercion. Instead, it may be that different parts of the Constitution use different verbs, and that should keep us attuned to the possibility there are many different measures of prohibited government conduct. And for freedom of speech, that's merely abridging or reducing it. But unfortunately, the Supreme Court ignores this distinction between abridging and prohibiting. It blurs the two standards together and thereby elevates coercion as the measure of speech violations. And we saw this most recently, about a month ago, in the arguments of the Supreme Court in Murphy versus Missouri, which is a case by individuals and two states seeking an injunction against the government's use of the platforms to censor people. And by the way, just to disclose my interest in this, the New Civil Liberties Alliance, which is my civil rights organization, it represents most of the individuals in Murphy versus Missouri. But one of the nice things of being to choose your litigation is I can pursue the truth both academically and in court, and I therefore don't see any conflict here. At any rate, we currently have First Amendment doctrine that echoes state action doctrine in inviting censorship by emphasizing something like coercion. The message for government is you can get away with censorship as long as you avoid overt coercion. Fourth, let's turn to the censorship itself. I want to see how it's structured to avoid or minimize constitutional obstacles under judicial doctrine. And I must say, it's unfortunate there is not a good general account of the structure of the censorship, and that's partly because it's so secretive. It's a covert system, and as a result, it's taken years just to uncover what we do know about it, and there's still more that gets uncovered every few months. So everything I have to say here is somewhat tentative. There may be more lurking around the corner. So the first thing to realize is that only some of the censorship is coercive. And that makes sense. There's much overlap in the government's and the platform's censorship agendas. They're not in disagreement about everything. So the government only needs to exert pressure at the margins. Now, of course, that coercion at the edges is serious enough because it concerns especially important suppression. For example, medical speech and election speech, right? So when some of the most important scientists in a field like Jay Bhattacharya here at Stanford is skeptical about government COVID policy and wants to point out some facts that seem to contradict it and that might be taken into account sensibly by policymakers, that's something the government really wanted suppressed, and it turned to coercion for that. Election speech, when there's election speech the government doesn't want, that thinks would subvert elections, that matters to the government, and little coercions seem justified. And then, of course, there were jokes about the president's family. I'm sure they were entirely in poor taste. But the First Amendment protects poor taste. And then, perhaps the saddest are private expressions of pain. This is the Dressen case, Dressen versus Flaherty. Some of the people who took vaccines and were actually pro-vaccine and voluntarily took vaccines and thought they would be cured by them, did so because the government suppressed adverse vaccine events. If you published an account, oh, I took a vaccine, I can't move my arms, that could easily get suppressed on the direction of the Surgeon General in the White House. So many people who might have paused went ahead and took the vaccines, and large numbers of them had very adverse effects. A little more than 20,000 of those people joined a private Facebook page run by Brianne Dressen, who's a medical professional. She's crippled. She's in a wheelchair. And some 20,000+ of these people are on this website. It's not political speech, and it's not even public speech. It's a private page. And what they're writing are things like, my legs don't work. Any suggestions? I've got a permanent headache. And that people would just feel sorry for that person. And so it was just a matter of getting a support group. And then, of course, there's Ernest Ramirez. He forced his 16-year-old son to take the vaccine. It didn't work out well. He just wanted to say, I'm sad. In any case, these are her clients. So this is private speech, entirely personal, and it's converted into political dissent because it doesn't fit the government's narrative. So here we get a little coercion because the government wanted to suppress stuff that wasn't within the realm of the platform's agenda. Now, even when coercing, the government was very careful. It did not want to go around saying, we are going to force you to suppress this speech. On the contrary, you know what it did? It created a division of labor. There's another way it evades the First Amendment. The threats and coercions come from political actors. The suggestions that you should take down speech come from administrative actors. And then the government in its briefs gets to say, there's no coercion. No person who asked for speech to be suppressed made any threat. And how true that usually was, because the threats just came from other persons in the administration. And so it was good cop, bad cop. One cop saying, gee, nice Section 230 you got there. It would be a pity if something happened to it. And others would say, hey, here's some speech you might want to take down. So the division of labor became a way of avoiding causation and coercion. Another mechanism, the government minimizes its exposure by running its censorship through private entities. Most prominently the platforms, but also through intermediaries between the government and the platforms. This is, for example, EIP and the Virality Project. Some small connection to Stanford here, I'm afraid. The private use of intermediaries was candidly to evade the First Amendment. Here, we actually get insight into what they thought was going on. Renee DiResta's notes for a 2021 presentation at the CISA summit was as follow. And by the way, there was a video of this too, which I used to have, but it was taken down. But the notes survive, and so I'm not worried that we don't have the video. In August, I'm quoting now, in August 2020, CISA and others identified a massive gap in the capacity of federal, state, and local governments to become aware of, analyze, and respond to misinformation and disinformation, both foreign and domestic, targeting the 2020 election. Notice CISA's authorities for foreign disinformation. She's talking about domestic as well. And then she says that gap had several components, such as, I'm quoting, unclear legal authorities, including very real First Amendment questions. No kidding. So privatization was their solution to the First Amendment problem. And in that, they read Supreme Court doctrine very well, of course. Blum basically says, yes, if you privatize it, you then have to have enough coercion to show that the private action is converted to government action. And of course, that leaves a lot of wiggle room. The government, moreover, couches its demands for censorship in uncoercive terms. It's all done very deliberately. Rather than say, we're going to take away your 230 rights if you don't do this, it says, let us offer you some information. Or, can we point out some misinformation on your website? And then it says, gee, I think you have some violations of terms of service. Of course, there weren't, sometimes they went beyond the terms of service, but the point is, they tried to put as much as possible into these anodyne terms. They also can't just traded policy for censorship. We don't have enough evidence on this, but it seems to have happened when Facebook wanted protection from European limits on data, what it calls data flow from Europe. The Europeans were threatening well over $1 billion in fines on Facebook for if it transferred Europeans' achieved data to the United States. And so they apparently made a deal. The government arranged that Facebook would not suffer European sanctions for sending data of European origin back to the United States. And in exchange, the government apparently got Facebook's cooperation in censorship. The government did not get this with any threats. There's no coercion there in any overt sense. Instead, it simply refrained from protecting Facebook. Normally, the government protects us when we run afoul of the Europeans. It just sat back and watched until Facebook agreed to provide this desired censorship. And then there's the question of, then there's deception. Deception becomes a mode of achieving privatized censorship. Notably, the FBI pre-bunked the Hunter Biden laptop. That is, the FBI prepared the platforms, spent over 6 months doing this, coaching the platforms to think that they know there's going to be some Russian disinformation coming. It was astonishing, like the laptop, that they knew would eventually be exposed. But they said, that's going to come your way. Be prepared for it. Be prepared. Essentially, this was government deception to get the platforms to suppress the story when it became public. And of course, we now know the FBI knew the laptop was real. They knew it was not Russian disinformation, but they used deception to get it suppressed just before an election. And by the way, there's nothing to do with whether you like the outcome of that election or not. That is so much not what's at stake here. It's about freedom of speech for everybody. And finally, I want to turn to one final mechanism, which I think is particularly important, widespread, and yet subtle, and that's coordination. This is the least understood but most prevalent mode of government privatization, of censorship. Even when just imposing their own private censorship, the platforms face a coordination problem. A platform's goal may be simply to sanitize its own site, to get off things that it doesn't want associated with its site. Or it could be to shape public opinion, and they do have those ambitions. But either way, it needs to limit the risk of losing users. You can't censor something without worrying that your users are going to go to another platform to see it. And you can't shape public opinion if the suppressed opinion is going to appear on another major platform. So the platforms need to coordinate. But here's the rub. They can't coordinate by themselves without antitrust difficulties. We want to talk to Facebook, says Twitter. Oh no, that's not a good idea, says your general counsel, and with good reason. But we have a solution for that. The government solves this problem by offering the companies coordination. The government directly and through intermediaries supplies guidance as to what's worthy of suppression. Each week there's topic or thing of the week that has to be removed. And they don't say you have to do it. They say, this is the topic for this week, and then everybody knows what can be suppressed, and knowing that your competitors are also suppressing it, thus allowing the platforms to align their censorship. All of these mechanisms reduce the freedom of speech, and they thus abridge the freedom of speech. But the government gets away with it because judicial doctrine tolerates sub-administrative privatized power. State action doctrine adopts a coercion yardstick, and because the First Amendment doctrine conflates abridging and prohibiting, thus reinforcing the coercion standard. Under those measures, government can do a little bit of coercion, but mostly can just use methods that are a little less obvious than coercion and get the same result. Finally, and fifth, I just want to briefly talk about remedies. Judicial doctrine leaves the censored without an effective remedy. In Marbury versus Madison, John Marshall said, "The government of the United States has been emphatically termed a government of laws and not of men. It will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right." Well, if there were ever a vested legal right, I would have thought that's freedom of speech, yes? Well, maybe not. The freedom of speech may be, in fact, without an effective remedy. Remember, when censorship was imposed through retail prosecutions, Americans did not need a remedy against censorship. They merely needed to defend themselves in court. You say, ladies and gentlemen of the jury, I didn't publish this, or I did publish it, but it's not as offensive as the government makes it seem. Now, under a system of wholesale suppression, the government is imposed outside of court. Americans therefore need a remedy just to get their words visible. So what are the remedies? For past censorship, the censorship that already happened, for example, to Jay Bhattacharya here at Stanford, the remedy would be damages. But that's largely barred by qualified immunity. The slightest ambiguity will allow the defendant to get off on grounds of qualified immunity. So what about the remedy against future censorship? Well, that would be an injunction. But it's difficult to get an injunction. The government can simply say, oh, you've brought a lawsuit against us? Well, actually, we just stopped censoring that plaintiff. So there's no likelihood of any future harm. You have no injunction, right? You just pull the rug out from you by just saying we're not going after your plaintiff anymore. What's more, neither damages nor an injunction are prompt or effective against secret censorship. This censorship was done in a very calculated way to be below our horizon, to be outside of our eyesight. And so it was in place for half a decade before any injunction was issued against it. It took 4 years to figure out what's actually going on. It took a year of discovery, and then you get an injunction. The net result is that even when you can get an injunction, it's not an adequate remedy for past or future censorship. Censorship for half a decade is much too long, and by the way, it's still continuing even with the injunction, of course. In conclusion, we should have judicial doctrine that stops censorship in its tracks. Instead, we have doctrine that has become almost an instruction manual for how to get away with censorship. Judicial doctrine invites censorship. It tells the government it can get away with it as long as it's privatized and not too coercive. In any case, thank you very much. I look forward to any questions.
Hi, thank you so much. Somebody gave me as a gift your book about the administrative state, so it's great to. Hello, here, yeah. So thank you for the talk. Somebody gave me as a gift your book on the administrative state, so it's good to.
Then you'll sleep very well, no doubt. Right.
and also one thing that I like, because we had this morning a different conversation at the Federal Society. You are also a practitioner of the law. You just don't teach it; you practice it. So I want to follow up on what you said about the U.S. Supreme Court. I also listened to the arguments. I'm not optimistic that they are going to side against the government. So what I see, my take and talking to other people is that the U.S. Supreme Court is going to side with the government, issuing some sort of nuance. And the question that I have is about the future remedy, because I suffer that. I was censored by LinkedIn twice. Once was in March 2002 about the COVID thing. I argued them, and I talked to one of the executives, and they brought me back, and I brought exactly the same things. I was censored a second time in July, and I never got that account back. That was because I brought up that Biden had issues in Ukraine that were not undocumented. That was when the war was going on, and it was all factual. It was given my opinion. The second issue was about that abortion case that happened in Ohio after the Dobbs that looked dubious, that not even the Wall Street Journal. So they censored me with those. They said, well, as a condition to go back to the platform, you have to accept that you were spreading misinformation. I said, no way. I was just giving my opinion. So I was blocked forever. I was lucky that Elon Musk bought Twitter a few months later. So I went to Twitter, and that has been my salvation. But we are relying on Elon Musk, a private actor, having a difference. So what would have happened, or what will happen if the U.S. Supreme Court, as a lot of people think, is going to rule for the companies, and there will be no remedy, essentially, to prevent them from doing what they're doing?
Right. Thank you, and I'm sorry that happened to you. You and many, many, many millions of people. So first, I don't like to guess what the Supreme Court is going to do. I don't do it in any case, mine or anybody else's. And that's because one usually can be quite wrong. One just doesn't know. The reality is, and I think some of the justices clearly recognize this, is this came up on a facial challenge, not an as-applied challenge. It's in a challenge to the law and the theory that there's no lawful application of it. And, sorry, I'm confusing two cases. You're talking about Murthy. Forgive me. Right, they talked a lot about coercion. I'm not sure I'm not sure that leads. I'm sorry they talked only about coercion. I think they should have looked at the Richmond argument. But there is a fair amount of coercion in the case. And that coercion was found both by the district court and by the circuit court. And so to the extent that that is a factual question, they have to really exert themselves to ignore the findings of the lower courts on the facts, right? So it may be that the injunction they leave standing is narrower than what we want, but I think they'll leave some of it standing. Having said that, I must say, the injunction already is too narrow. They don't seem to get that. And so I think it'll be a great misfortune if they narrow the injunction, but we'll see. Now, as to the Elon Musk issue, that's very interesting. I don't know if you've read Tocqueville, Democracy in America. So Tocqueville contrasts America and France. In his home country, in France, he says when there's a public problem, the solution comes from the aristocrats. People will rally around an aristocrat, and the wealthy aristocrat will lead their opposition to the problem. In America, he says it's different. There is no aristocracy. Rather, the people themselves get together and form organizations which, in an egalitarian way, push back against the problem. I think this means, very sadly, we are now 19th century France, right? We need an aristocrat to help us rally around, to fight back. This is true in politics, it's true in journalism. It's all very, very worrisome. And I think it's part of a larger problem, which it's not just in this that we're like 19th century France. 19th century France, 1830, 1848, is a society divided by class, right? And politics becomes overtly a mechanism of class oppression and conflict. That's pretty ugly stuff. And I don't think we're that far away, all of which saddens me. I didn't think that's what our politics should be about.
I agree, and thank you for the comparison. I am originally from Spain. I'm a naturalized citizen, and I was having the conversation this morning with the gentleman that this is what Franco, all dictatorial regimes, they say, oh, we apply the law, blah, blah, blah. But what I think is, we are one Elon Musk death away from total censorship. That's the conclusion.
Yeah, well, let's wait and see. Hopefully there'll be some justices on the right side too.
Thank you.
Thank you.
Good evening. In a modern digital platform, when some content is censored, is deleted. In a modern digital platform, when something is censored, get deleted. But there is a new trend that make content less visible, like shadow banning or diminish the reach. And there is some theory for which this is a more subtle form of censorship, and someone else call it not censorship. What is your take on it?
Right. There are a lot of clever devices being used, and I don't think we know all of them. Yes, one could simply remove a person, say you can never publish on our platform again. That's actually beyond anything in the 17th century, right? Where they just censored particular materials. And then, almost as crude, we're taking some material off the web. That particular post is banned. That's bad too. But far, far more common is what you call shadow banning, in which your piece remains there, but ever fewer people see it. And sometimes it's done just gently. So 1 month, 90% of the people can see it, then 80. And after 10 months, just your friends can see it. There are versions of this which are even more amusing or cruel, in which you shadow ban someone, you limit so that no one else can see it, but you don't let someone look at the statistics and see that their viewership has gone down. No, you boost it. You tell them all sorts of people are looking at you. You even have an algorithm telling them, I love your posts. So people are commenting on your posts saying, it's great, I love reading this. And it's all BS. It's all designed so you don't notice you've been censored. I think this is all censorship. All of this, at least when done by when orchestrated by government, I want to make that distinction, when orchestrated by government, is a mode of abridging the freedom of speech. And by the way, anyone who works at the platforms and wants to share, people tell me about these mechanisms. I'm always open to hearing about them. It's my sick form of amusement.
Yes, my name's David Paul, and I often introduce myself as a private citizen. And sometimes that gets me a good laugh. Now, the reason I do that is because I'm in America. And as a private citizen, I don't let anybody tell me to shut up, especially when I know what I'm talking about. Now, I noticed that the first step in running for office usually was establishing that you could raise the money. So I developed techniques that required less money, and these been successful. But I found people were not willing to use these techniques for two reasons. They required you to do things that weren't exactly seen as that of an aristocrat. You got to walk some precincts. You got to design your own literature. You got to know how to write editorials. You got to develop skills, and you got to use them together. And you have to have a group of people you can trust. In America, that doesn't exist because people don't know who they can and who they cannot trust. But also, they want to look like a big shot. And if you go and do something like put up 4x8 signs and people see you doing it, they think, that guy, he's not a big shot. I'd win the election, but I'm not a big shot. Anyway, we got to start looking at what we think and how that affects how we act. Thank you.
Thank you very much. If the suggestion is that too many Americans are conformists, I would agree. I fear human nature. Thank you.
Thank you very much for your remarks. I'm at the law school here, but I'm not a First Amendment lawyer. And so it's a genuine question. I've often heard people comment about the distinction between the freedom of speech and the freedom of reach. And it seems to me that a lot of what you are addressing might be concerned with freedom of reach. I mean, Jay Bhattacharya, for instance, everyone in this room probably knows about Jay Bhattacharya's views on COVID, right? Even though he was either algorithms downplayed or removed from Facebook, he had the chance to express himself, and that message was delivered. So I'm wondering, again, if you could help me understand whether everyone is entitled to have maximum exposure on all platforms of their message, if that's what the Constitution requires. Thank you.
Right. It's a good question. Thank you so much. I would never want to suggest that everyone has a right to bloviate at length and force people to listen to them. All that I'm talking about here is the government's attempts to use the platforms to suppress speech. There is a different question, which I'm also very interested in, which is what liberty the platforms have, right, to limit speech. That's an entirely different question, and it's much more complicated, it seems to me. One of the nice things about being an academic is you get to choose what you argue, and I've chosen, in a sense, what I think is the easier argument here, which is simply to argue that the government should not be orchestrating the degree to which people are free to speak and which opinions can rise and which cannot. It's essentially viewpoint discrimination on a massive scale. And that's unconstitutional, whether the government does it directly, says, oh, Hamburger, you can't talk about this, or whether it goes to YouTube and says, tamp down some of that hamburger stuff. And maybe I deserve to be suppressed, but generally I don't think anyone else should be suppressed. And it seems to me, that when you're talking about the government, we have a pretty clear line in the First Amendment about what it can't do. That isn't to say, and I don't know if this addresses your question, because I don't know to the degree to which you're talking about the platforms of the government. There's this other very complicated question as to whether the platforms should be able to manage to some degree what appears. Of course, they have to do that to some extent. There is a question as to whether they should do this based on content or based on viewpoint. One of the risks, and this gets beyond this question back to the government suppression question, one of the risks of having platforms with so many people on them is that it's as if you're back in the 16th century when there were just a handful of printing presses in England, right? There was a time when the Privy Council had lists of who had a printing press. There might be at most 15 of them, sometimes just 7, right? And when you had so few printing presses, yes, opinion could spread by manuscript. That's how you did surreptitious Samsadat-style expression. But you could do a vast amount of control of the press just by controlling the printing presses. And unfortunately, we're back in a similar sort of situation. It's not that any one company has a monopoly, but they are very dominant in different slices of the communication market. And so 5 or 6 big companies can be used by the government to control a lot of speech. And that's worrisome, right? So I think the danger is if one has such very large companies with so many users, that it's almost an irresistible temptation to government to abuse that. So there's a problem here that doesn't have an easy solution. I mean, what it should be, we can discuss afterwards in detail, but I hope that's helpful. Fire away.
Hi, thank you again for your remarks. I'm a student here at the law school. I'm really curious, thinking of other methods of control besides outright banning, what your thoughts are on demonetization.
Right. Yes, thanks. It's very similar. It's similar in some ways to the question about shadow banning. Demonetization has a very similar set of effects, right? I have the luxury of having my overhead covered by Columbia Law School, right? So I don't have to worry about making money from my books, which is good because when you have a readership of a dozen at most for a book, you don't want that to be your income. But most people who write have usually done it for money, right? This was true in the 18th century. It's true today. Money isn't speech, but money is the way people subsidize their speech. And money is actually a good way of figuring out do people like my speech and so forth. So it seems to me that demonetization is very much a means of suppressing speech. And if this is orchestrated by government, I think that's unconstitutional. Yes.
Philip, I'm curious to know what line you're hoping, if you had your druthers in the Supreme Court, what line should they draw? You're critical of the coercion line, but I'm wondering what the alternatives are. Do you go so far as to think that government officials should not be able to communicate at all with social media companies? For example, the FBI would not be able to tell a social media company about a terrorist organization that's recruiting on the platform, or is there some other? But if the government can communicate with them, where and coercion isn't the line. What is the line?
Right. Thank you. That's right. And I'm glad you mentioned the FBI. Let me just set a bit of factual context and then delve into this problem. It's said that the FBI at one point had 80 agents working with the platforms. That's an extraordinary number. And it's not just FBI agents. There is an unusually large number of former members of the intelligence services, particularly the CIA, but also others, working in the platforms specifically on controlling speech, which is sort of reminiscent of some practices back from the 1950s and 60s. But it's just huge numbers. There's a story there. This is not just a coincidence. So yes, the FBI has been very much involved. And it's not clear what really the remit of the FBI is in controlling speech. Now, of course, I think you're absolutely right. There has to be a fair amount of communication between the government and the media, and there always has been. And at one level, that's simply, if somebody about to publish a story that contains national security secrets, the government should be able to call and say, are you sure you want to do this? This is going to be very damaging to the United States. And depending on the publication, they'll either say, oh, no, we won't publish this, or yippee, we got good stuff, we're going to publish it regardless. I don't particularly like that attitude, but some publications have it. But there has to be a line somewhere, I agree, and the question is how to draw it, and it's very difficult, isn't it? Maybe we I'd like to distinguish two different lines. One line, which is the constitutional standard, and the other, which is more complicated, which is the measure of, let's say, an injunction, okay? So I think the constitutional measure is that there should be no law abridging the freedom of speech. That may seem as if it might interfere with the government. I actually think it's one of those rare moments when the 18th century text is actually illuminating about 21st century problems. Why do I say that? First of all, it doesn't say any phone call, any chat it talks about a law, or you might say a policy if you think of an administrative government these days. It seems to me only when there's a law or a policy that takes aim at the press that we really run into some difficulty. What's more, it talks about not abridging speech, but abridging the freedom of speech. In other words, the mere fact that a particular article or post gets suppressed does not trigger a First Amendment problem. It's only when you have a policy that takes aim at the freedom of speech. Now, how does that play out? A single phone call, let's say to the New York Times, is neither a policy and nor is it aimed at the freedom of speech. It's just at a particular piece of speech. At the other extreme, of course, we have the current situation in which there is clearly government policy, which connects to the full range of dominant platforms about particular points of view and to suppress them. I think that clearly falls on the wrong side of this. Now, between those two extremes, it may be very hard to draw the line, right? But it seems to me it's quite clear that we have a law, not a law, but a policy of government, which is abridging the freedom of speech because it's aimed at particular points of view across the full range of platforms. It's not worried about a particular item that's worrying them. So this seems to me clearly on the wrong side of that line. And again, it'd be very difficult once we narrow it in and try to find some less simple extreme examples. Before leaving this, I just want to get to the other line that has to be drawn, which I think is even more complicated, which is what line should be drawn in an injunction. It's already an imposition on us to require us to get an injunction to liberate our speech, but that's the situation we're in. And you can't have an injunction that simply says obey the law. It has to be quite specific. I would have thought that one line that could be taken in an injunction is simply a prohibition on government taking aim at lawful speech. It's really the government has no business trying to suppress lawful speech. And you might say, well, what about national security? Most national security questions are, the publication was unlawful speech. Now, if you had to, you could carve out national security's exceptions for that, but it would have to be about foreign problems, not about domestic political dissent. So those are some initial thoughts on that. But it seems to me the second question about the line drawn in an injunction is much more difficult. I don't know if that will satisfy you. Looking at your face, I'm not sure it does.
Well, I'm not sure what you mean by policy.
Okay, sure.
What is the policy?
Right. So the First Amendment assumes a pre-administrative state, right, in which regulation is done by Congress. Congress regulates commerce. Congress makes laws. We now live in administrative circumstances, right, in which a lot of legislation, regulation, good, bad, constitutional, unconstitutional, is done by agencies, right? And sometimes it's done with rules, so at least it's labeled a rule, and you can see it in the Federal Register. But a lot of government policy is of a sub-administrative sort, right? And I think here we quite clearly have a policy adopted from the White House down, right? They're quite explicit about it, about trying to discourage certain sorts of bad speech, bad thought, right? So I think the current censorship is pretty clear on this. I can imagine a lot of instances in which it would be very hard to figure out what's policy and what's a one-off decision. And I don't have a neat answer for that.
I'd like to add.
So this guy hasn't asked a question yet, so let's give him a chance.
So I take your point that the First Amendment is directed towards the government, and certainly the 14th Amendment is. And some of the aspects of the traditional limits on the authority to regulate speech by the government were specific to the government, rule against prior restraints, for instance. But insofar as the First Amendment is recognizing a natural right, or insofar as a state-level provision was recognizing a natural right, the natural right would have paradigmatically operated against private individuals, and then it also might impose some limits on the ability of the government to regulate it. And my question is, what can we learn from that about what you're talking about? So the fact that at a state level, so I want to kind of take away the First Amendment textual overlay and just think about conceptually the idea that you have a natural right that operates against not only the government, but also against private individuals. And furthermore, the government has the ability then to regulate and protect that natural right. So that's introducing a kind of private public blurring that is less clean than what you've been talking about, but seems also to be kind of foundational to how people back in the day thought about the underlying rights that's secured by the First Amendment. And I'm just having a hard time thinking through what that might teach us here, and was curious about your thoughts.
Thank you. I cannot begin to express my gratitude to you for asking that question, because one of the first articles I ever wrote on 18th century America was the Yale Law Journal piece on natural rights. And specifically, the example was the freedom of speech. It is utterly conventional in the 18th century to describe the freedom of speech as a natural right, and not unreasonably, right? Because this is speech, or even printing, is something you can do in the absence of government, right? Now that's very useful to know about. Why? Because it helps us understand what it is that's being protected by the First Amendment or a state provision on freedom of speech, right? Now, what's the private element that he's talking about? In the natural law vision, one has a natural freedom, but it's not a physical natural freedom. One could have just talking about physical discretion or physical freedom. What they're interested in is one's moral or non-injurious freedom, natural freedom one has in the absence of government, subject to natural law, by which they meant most basically a rule of not injuring others, right? That because when natural liberty is equal amongst all persons, one shouldn't infringe on somebody else's natural liberty. Much regulation can be viewed as protecting the interacting natural liberty we have, right? Protecting my speech from interfering in, let's say, in your natural right to your reputation and so forth. And so once you recognize that freedom of speech is a natural right, that doesn't mean it's unlimitable. It actually becomes a justification for a fair amount of regulation, doesn't it? Now, it's only a theoretical account, so it doesn't really answer many of the practical problems, but many of the Supreme Court rules we have trying to figure out what speech can be regulated and what can't, hark back, at least loosely, I think, although unbeknownst to the justices, to this distinction between freedom of speech and the injurious use of speech. I'm not sure that fully answers your question, but I think it's a very important point you raise.
With apologies to those who are lined up with other questions, our time is now up. So please join me in thanking Philip Hamburger for a fascinating presentation.